But I heard of update without the certified. The order was passed on last week, and the RTL says that from the next week, the counseling is in respect of second SLST stuff. But I have not been given the marks for prior teaching experience. My contention is that
what is the urgent?
If I get the marks, then I'll be able to
then certificate copy and
certified copy has been applied.
when did you apply?
The day after it's 11th is the order. On 12th it was done.
So you take steps, you get the certificate copy.
And it was
all leave cannot be done.
The next week, the counseling will be starting. I'll be
so what? You are not there in the list. If we hold in your favor, you will get.
After the counseling is over, it will not be.
Counseling will not be over in a single date.
And the interviews,
that will not be over. I don't understand why don't you send your clerk and take active steps for obtaining the certificate. This is becoming a nature and a habit. It is becoming a habit. Let us file an appeal.
File the appeals to lot of
why should we allow? There is no such urgency in the matter. You obtain the certificate copy. Maybe.
We understand that in some cases we go come to the lordship for leave.
Call the list.
Item number 1. Find
it out today. If you don't get, come tomorrow.
And according to your last order, Raghu's Act 53 with Can 1 and Can 2 was completed on. So after that, two similar matters were filed max. Saidul Islam Mat 123 Can 1 and Can 2 and Mat 152. So these are similar matters. Then it follow with Raghu's.
What I am about the respondent number 10. Where did she go? She was mentioning. You're appearing for whom? Appellant in person is appearing.
No, I was mentioning.
It is not the mentioning date. Yes. Item 1.
Yes, my lord.
You are for whom?
I am on behalf of respondent number 10. Lokhi, Srimati Lokhi Das.
Yes.
My lord, item respondent number 10, Lokhi Das ke যেভাবে অথরিটি লাইসেন্স প্রদান করেছে মাই লর্ড সেটা গভর্নমেন্টের অর্ডার এবং নির্দেশককে নির্দেশিকা রয়েছে সম্পূর্ণটাই ভায়োলেট করেছে মাই লর্ড এই বিষয়ে মাই লর্ড আমি একটা প্রমাণ সহ মাই লর্ড তথ্য বলালাম সেই তার কথা নয় মাই লর্ড আমি একই করে সমস্ত তথ্যগুলো
দাঁড়ান
He has the intention just way.
Where is the advertisement notification?
One,
Para 4.
Clause 4 the application to further the suitable go down as per the notification. The area of go down should be minimum 400 square feet. 300 square feet is of immediate along the forward face of it 200 square feet. The application matter is the application 120
Yeah, just. And where is the order of September 23 rejecting this prayer? 14 September 23. Pardon?
Past litigation, my lord, is an order of
That is 14.
presentation to consider, my lord. That was considered by the negotiators.
3.
What order was passed?
You keep quiet.
Mr. Chief,
Take your seat. When we call upon you, you will answer. Take your seat.
my lord. 14th September. Valid, my lord.
Where is the inquiry?
Inquiry number 240, my lord. We filed one application report that commitment to 31, resident person 230 of the inquiry.
This was prior to the order. This was before granting of license to transfer numbers. But applicant here is Mohammed Shamim.
Yes, my applicant, the applicant here is my lord.
Acha. Where are the details of his area?
area madam, 42 cross 50 madam, next page madam. Page 42 cross 50, details of the subcom go down. Dimension to it go down. Height of cell counter madam, that is 122.71. Minimum requirement is 12. That's what the specification of the house.
The sales counter. And the go down should be a 400.
400 square. The minimum 400 square.
Go down 400 plus 200
200
is the office space.
Office building. Cross 50 minus specifically height of the cell counter 122.72 square feet. The truck also applicants offered the living room to go down, converted living go down as first. First one to go down as backward in
Where you are reading?
I don't know the same page minus 40. Cross 56 minus. That's the remark.
Yes.
And that's the loophole of the application. The godown is not completed. The proposed godown is not suitable for storage. Madam, next page, madam. Cross 65. Overall comments with positive and negative recommendation. Next page, madam. 243. The proposed godown is not suitable for the storage of within the area of the proposed encounter. The less than the government order. As per the regulation. One is where the applicant did not submit the evidence on the magistrate court as per the annexure 1. In view of the above, the applicant other.
Now, where is the inquiry he put in respect of Lokhi?
Madam, next one. 242 onwards, madam.
I see.
50 madam. 425 square feet, 59 square. 250. Last page. In view of the above, the applicant fulfills all the new criteria for engagement of new criteria and the applicant is recommended. Madam, next page.
Now, in the exception, what did he say? In his exception.
My lord, the next page, madam, 48, madam, there's a detailed postage, madam.
After inquiry.
48. There, Muhammad Khan, my report, my lord, 58 marks. Copy the report. My lord, overall 74, my lord, 68 marks. Okay, can you please go over the director of city, please?
Where is the order by virtue of which considered?
My lord, that was
As we annexed it.
yes, ma'am. 174, my lord. 178. 178.
170. Or 170.
He has admitted.
Here, madam, admitted that below the
Paragraph 18 of the writ petition. হ্যাঁ বলুন
my lord.
that writ petition is annexed here.
মাইলর এই ইনকোয়ারি রিপোর্টটা দিলেন, এটা হচ্ছে ম্যাডাম এসআই সাহেবের করা ইনকোয়ারি রিপোর্ট মাইলর। এই আমাদের এলাকায় যেগুলো ডিলারশিপ নিয়োগ হচ্ছে মাইলর, এসআই রা যে কিছু করে ওকে যদি কমেন্ট করে দেয় তাহলে ওটা লাইভ হয়ে যাচ্ছে। এভাবে এসআই সাহেবরা মানে যার মানে দুর্নীতি করছে যার তো করে কমেন্ট করে পাঠাচ্ছে মাইলর। ওই দেখলাম যে আমার অ্যাপ্রুভ হয়নি, যার মানে যোগ্যতা নাই তাকে রিকমেন্ড করে দিয়েছে। সেই মর্মে আমি অ্যাপ্লিকেশন করলাম গভর্নমেন্টে দপ্তরে, কোনো কিছু করলেন না। সেটা আমি বাধ্য
এই
হয়ে-
অভিযোগ আপনি আগেও করেছিলেন,
হ্যাঁ
তারপর আপনি রিট পিটিশন ফাইল করেছিলেন। আপনার রিট পিটিশনটার অর্ডার দিয়ে কোর্ট বলেছিল যে এর অ্যালিগেশন গুলো কনসিডার করা হোক।
হ্যাঁ ম্যাডাম
লোককে একটা অ্যাপিল করেছিল, অ্যাপিল কোর্ট কিছু করেনি। তারপর অথরিটি কনসিডার করে দুজন কার কার কত অফিস স্পেস, কার কত গোডাউন সব কনসিডার করে অথরিটি একটা অর্ডার দিয়েছিল।
হ্যাঁ ম্যাডাম
সেই অর্ডারটা আপনি চ্যালেঞ্জ করেননি।
করেছি ম্যাডাম
আপনি সেই অর্ডারটা কোথায় চ্যালেঞ্জ?
করেছি ম্যাডাম।
এই অর্ডারটা চ্যালেঞ্জ না করে আপনি নতুন একটা রিট ফাইল
না ম্যাডাম করেছি ম্যাডাম, অনেকবারই বারবারই ওটা কথা শুনেছি ম্যাডাম, কিন্তু
কোথায় তুলেছেন? আপনি রিট পিটিশনটা এনেছেন?
এনএস করা আছে ম্যাডাম।
আচ্ছা, রিট পিটিশনের পেয়ারে কি লেখা আছে আপনি দেখুন।
In the above circumstances, the petitioner are most humbly where that your
1 minute.
এই কথাগুলো লিখে ভিতরে থাক না।
হ্যাঁ, এইখানে পাঠিয়ে দিয়েছি। ওরা consider করেছে। হ্যাঁ, পিটিশনার আছে
মাইলর করেছি ম্যাডাম, পেজ নাম্বার 22 মাইলর।
5 marks of the side, এইখানে একটা মার্কস করা 400 হলে 5 নম্বর,
রিট পিটিশনে মাইলর
5 নম্বর 5 নম্বর ও। With the number awarded to the team. Take after them. Mark the size of godown. এই যে মোহাম্মদ সাহেব আমি পাঠ পেয়েছি 400, তো কেউ 500। এই যে লক্ষ্মীরা ফিরদৌস আলম নাম্বারে রেজিস্টার হচ্ছে মোহাম্মদ শামীম ওপরে নাম্বার 5 নম্বর পেয়েছি, লক্ষ্মী দাসও 5 পেয়েছি। এই যে 400 হলেই 5 পাবে। এর একটু বেশি 463, কিন্তু লক্ষ্মী দাসের 425, কিন্তু লক্ষ্মী দাসের 200 স্কোয়ার ফুট অফিসটা আছে, ওখানটা ছিল এর 120 22। হ্যাঁ, 63 মধ্যে 100। জন্য লক্ষ্মী বেরিয়েছে। গোডাউনটা 463, এবার ওটা আসছে না। কিন্তু ওইখানে একটা নম্বর আছে। ওই নাম্বারিং সিস্টেম, take us to the numbering system. Numbering system 5, 10, 15, that page. 248.
So if Lokhi Das
Oh,
is
no. The full marks, full marks.
That is proceed, madam. Operating chart, madam. 2.21.
oh, for size of godown, you have given 5 to him, 5 to him also. But his area of godown is
Hey,
463.
Basically, my lord,
Come to page 126.
not even given any marks, ma'am. It's not
126.
even qualified basic criteria. That
He has
is-
given marks, 5.
that is, madam, is the wrong one. Because he is not fulfilling the basic criteria of 200 square feet. He cannot talk on the zone of
That
consideration.
is separate, that is at office. 120.
That is good, Your Honor.
126.
Total inquiry, my lord, district level paper association, my lord,
এই হচ্ছে 400 থেকে 505, 450 এবং 426.
Come to the order passed while relegating the matter to the officer. Come to page,
DCF order, my lord.
that is page 200 and fourth order.
204. 2 থেকে start.
Where is that order?
203.
No. Page 176. Where you showed that he admitted. 176 last page. Last para now. Kindly come to 177.
176, my lord.
We have seen that. Now 177. Having heard the learned advocates.
For the parties and of resolution.
On these two counts, what does it mean?
Counter, my lord.
Go down and office. So for go down, he was given 5 because it is 463.
March.
With the tabulation. That is
Page 248.
248, my lord, that is
No, this is what we the circular regarding allotment of marks. Also that
126.
127.
126. Volume 1.
126. 126 says but the 400 to 500, 5 marks. Now, what is the meaning of this observation of the court? Having heard it is found that as per the memo of 7-year petitioner was entitled to get 5 marks, size of shop cum distribution center. The petitioner was not given any mark on these two counts. Why it is being said? I am also of the view, if the inspection team found there are 2 doors in the proposed go down, the petitioner could have been asked to close one door before considering the size and suitability of the go down.
I don't get that observation that there is a backdoor entry here.
Yes. So court observed that the inspection team should have done this. This finding has attained.
That is here. There is no conflict between go down, my lord. Then the main crux of the matter is of 200 square feet, but he is not the 200 square feet. You want to this count. At least he is 200 square feet required. Go down is one, my lord, you are avoiding the mark.
So with the
Now,
guideline.
why it is said petitioner was not given any mark on the two count?
Earlier.
Because the inspection team, this was an observation of the court.
Yes.
So where did you consider this in the recent order? In the recent order which you passed, that is page 203. Where is that discussion as regards the observation of the court? That had the door been closed, No, no, we are not saying that. Your ultimate remark was, your ultimate remark in the inquiry report you showed us,
Yes, my lord.
that is page,
That is page, my lord.
that is page 241, 42. Applicant converted living room
Go down
and has backdoor and roof is of corrugated sheet. Roof of the second person. So this applicant converted living room, the go down has two parts. First part of the has a back door. So as regards this report observed that there are two doors and the could have been asked to close one door before
My
one.
lord, regarding that observation of the court, my lord, that is come before the department, my lord. My lord, regarding go down is concerned, my lord, that was the, my lord, assuming that the go down is fit for story. Regarding the scale counter is concerned, my lord, that is fine for shares, my lord, overall remarks, my lord. Two for view of the above applicants unable to fulfill the eligibility criteria for engagement of new FPS hence the application may not.
Observation.
That is the overall recommendation regarding scale counter is concerned.
These are observation before the guideline. Guideline only doors are
But that is my not the suggestion.
not a suggestion,
An authority can
it is a direction that I am observing this you consider. That order has not been assailed, you did not challenge it. Appeal
What
favored
is
by
this
private-
number? Come to page 248. What is this number? Marks by DA,
at district level they are by the selection committee.
district level?
They are by first selection committee. There are some three members are there, ADM group. One is DC district controller, the district manager and the PCA sub-divisional controller. The three members committee, they evaluate the all lectures reports, they put marks on 25 marks.
No,
That is the issue to Mala.
There the appellant has been given 10, whereas
10.
private respondent has been given 9.
19.
Why?
Why not regarding the interview is concerned? All papers, all the records that take place before the entire
Where
review.
is that government circular regarding district level fair price? Is it there?
Category of the applicant. Mark for category of the applicant.
Which is
Interview now, interview 9 interview number বেশিতে ওনাকে সিলেকশন করা হবে আমি
উনি তো কম পেয়েছে ইন্টারভিউতে তো উনি কম পেয়েছে
আপনাকে বেশি দেওয়া হচ্ছে না ওনাকে 19 দেওয়া হচ্ছে আমাকে 10 দেওয়া হয়েছে
127 minus
127
was sending the report minus
127
127.
yes
Cross 4 minus before sending the report DGNS to the district magistrate. The DCFS shall raise the matter for the district level hereby from selection committee. Constituted for purpose of comprising of following officials. Additional district magistrate, district controller food and supply, sub-division controller. Each member of the district level preparation selection committee evaluates the application from a scale of 0 to 25 to determine suitability of the candidate from almost the eligible applicants. The average of the marks received by the applicants have gross marks secured by the union. Consider necessary. Take personal interview. There's no mandate to take personal interview. If necessary, take personal interview of the eligible applicant to find suitability of the applicant.
লোকটা
Make recommendation. Subject of the recommendation.
বলছে 122 স্কয়ার ফিট he doesn't fulfill the condition. Then how he was found to be তুমি ওকে নিলে ইন্টারভিউ
200 স্কয়ার ফিট বলে
আপনি 127 আসেন 100 মানে যে এলিজিবল তারা 100 থেকে 200 হচ্ছে 5 কেউ 5 পেয়েছে ও 5 এবার
না,
ওর
ওইটা
যে
নিয়ে ওদের
200
কোনো-
আর কি সেটা ইন্টারভিউ বেশি না পায়
না না ওটা দিয়ে বক্তব্য ওদের বক্তব্য সব
Basically, one of the
you have no problem as regards the go down.
earlier kind of super might is
The office report, the office portion would be minimum 200. His is 120.
120.
So he is not an eligible person. Then why he was called for
That
that?
is the next calculation is given 5 marks. Instead of 5 marks, is RM is given 0 marks.
No, 5 marks rightly given because his income is more than 400.
Getting
Office.
office space.
Office space is 200. Then if he does not fulfill that, why he was called for interview?
My lord, that is the process of all the interview, that he is not given an interview, my lord. But all the papers were placed before the district level papers. He is necessary to take the interview, my lord. In this case, there is no interview. One twenty, my lord.
No, requirement is that there must be a godown of 400 square feet,
Minimum criteria.
along with a covered space of 200 square feet to be used for office purpose or counter purpose, whatever may be.
That particular one twenty.
Now, yes, so below 200, this will give an impression that below 200 would be ineligible. But you come to page 127, while numbers has been allotted in this fashion, that size of attached shop cum distribution center, 401 square feet, 10 marks, 301 to 408 marks, and 100 to 201 square feet, 5 marks.
তিন নম্বর এক্সট্রা আবার দেওয়া হয়েছে।
Because my lord, the notification covered my lord hill area also. My lord, petition
Oh.
120.
No, this one the size of attached shop.
And that's the proximity between the godown and so my
এটা
lord.
হচ্ছে কি করে ও সার্কুলারে তো করছে
অ্যামেন্ডমেন্ট হয়েছে তাই।
200 along with cover space of 200 adjacent to go down to be
Right.
used for office purpose and for FPS automation.
covered space,
There is shade no, there must be shade.
covered space.
You are the owner of the property. You are the owner of the property. Huh?
না ডিলিভারি প্রপার্টি মানে নোটিফিকেশন যেটা না
এটা বলছি মানে
এখান থেকে
should possess.
ওই যে এবার 127
marks allotted.
সাইজ অফ অ্যাটাচড
হ্যাঁ, size
এটা
of
বলছে মিনিমাম হচ্ছে 400।
120.
না, এটা show।
হ্যাঁ, তাহলে এখানে মার্কসটা দরকার।
100 থেকে marks দেয়
My lord, there is the notification of the 124 my lord. The applicant to follow the switch go down as per the notification for the Department of Food and Supply height certificate notification as amended, my lord, as amended. 127, that's the amended. In the vacancy location, storage of the area of godown should be minimum 400 square feet. And my lord, 300 square feet is case of hill area. And my lord, along with the covered space 200 square feet, 100 square feet hill area. Marking is there, but 100 square feet, 500, my lord. So, we're
Yes.
saying that 100 by 100 square feet.
Yes,
Yes.
Hill
Hill area, 100.
That is
Hill area,
the
100.
breakup.
Okay.
it is an hill area.
Hill area,
হ্যাঁ,
not hill area, my lord, overall.
hill area 100 মানে 100
The hill area is there, instead of 100.
Understood, understood. Anything below 200, no marks.
No mark. Not even eligible, my lord.
Sorry, sir.
মাইলা বললেন যে এখানে 1707 নোটিফিকেশন ছিল যে 200 স্কয়ার ফিট মিনিমাম এবং 200 স্কয়ার ফিট লাগবে সবটা মিনিমাম, কিন্তু ওটা 17 আগস্ট 2021 সালে অ্যামেন্ডমেন্ট করা হয়েছে এবং সেটাকে কমিয়ে দেওয়া হয়েছে। বর্তমানে
কোথায় পাবো কমিয়ে দেওয়া হয়েছে?
এই যে মাইলা অর্ডার 126 পেজ নাম্বার।
হ্যাঁ, কমিয়ে কোথায় দিয়েছে? কমায় তো নেই। আপনি 127 পৃষ্ঠায় আসুন, উপরে দেখুন কি লেখা আছে, সাইজ অফ অ্যাটাচ শপ কাম ডিস্ট্রিবিউশন। আপনারটা 200 নিচে, আপনার হচ্ছে 122 অফিস স্পেস।
অ্যামেন্ডমেন্ট করে বলা
হিসেবে
I did
122,
হ্যাঁ মাইলর
122 হলে আপনি আপনি এন্টাইটেলড হচ্ছেন না।
মানে
যদিও আপনাকে 122, যেহেতু ওরা আপনাকে 5 নম্বর দিয়েছে, আপনাকে 5 নম্বর, আপনার বক্তব্য হচ্ছে ওই ডিস্ট্রিক্ট লেভেল কমিটিটা ওকে 19 নম্বর বাড়িয়ে দিয়েছে যাতে আমাকে বের করে দাও।
হ্যাঁ,
এইটা যেটা আপনার বক্তব্য, এই বক্তব্যটা আপনার বলা ছিল ওই অর্ডারটা চ্যালেঞ্জ করার সময়। আপনি তো ওই অর্ডারটা চ্যালেঞ্জই করেন।
চ্যালেঞ্জ করেছি মাইলর, পেজ নাম্বার 22 মাইলর।
হ্যাঁ, চ্যালেঞ্জ করার পর তো কোর্ট বললো আমি পাঠিয়ে দিচ্ছি পুনর্বিবেচনা করার জন্য।
হ্যাঁ
পুনর্বিবেচনা করে একটা অর্ডার দিল।
ওই ওই অর্ডারের পরে লাইসেন্স ইস্যু হয়েছে মাইলর।
হ্যাঁ, কিন্তু আপনি ওই অর্ডারটা চ্যালেঞ্জ করেননি। কথাটা বোঝার চেষ্টা করুন। আপনি কি করেছেন, নতুন করে মামলা করেছেন ফ্রেশ গ্রাউন্ড দিয়ে। কোর্ট সেটা বলেছে অ্যাকসেপ্টেবল নয়। আর এইগুলো হচ্ছে ইনকোয়ারি অফিসারের ব্যাপার। রেকর্ড থেকে কোনো ওর প্রতি যে ওদের সহানুভূতি আছে কি ওদের করাপশন আছে এটা প্রমাণিত করা যাচ্ছে না, সম্ভব নয়।
মাইলর আমি রিট পিটিশনের 22 নম্বর পেজে আমি ওটা কথা তুলেছি মাইলর।
আর আপনি নিজে
ও, ও।
অ্যাডমিট করেছেন যে আমার অফিস স্পেসটা ছোট। নিজে
আমার
আপনি
যেহেতু গাইডলাইন 2750 যেটা হিল এরিয়া আছে 2700
আপনার তো হিল এরিয়া
50
নয়, আপনার তো হিল এরিয়া নয়।
আমার হচ্ছে 2750 মানে হচ্ছে সমতল এরিয়া।
হ্যাঁ, হ্যাঁ, হ্যাঁ।
ওটা হচ্ছে যিনি বললেন উনি বললেন হিলের কথা, আমার তো হিলের কথা আমি এখানে বলিনি মাইলর।
হিলের কথা বলছেন না উনি। আপনার গোডাউনের সাইজটা 100 থেকে 200-র মধ্যে যদি হয় আপনাকে মার্কস দেওয়া হবে, এবং ওরা আপনাকে 5 নম্বর দিয়েওছে। 148 পাতায় দেখুন, 248 পাতায় দেখুন।
হ্যাঁ মাইলর দিয়েছে
সরি,
মাইলর। এখানে আমার কিন্তু আরো বলতে পারেন
আমরা শুনেছি।
মাইলর। এবার ডেপুটি ডিরেক্টর যিনি ইনকোয়ারি করেছেন এসআই ইনকোয়ারি কোর্ট, ডেপুটি ডিরেক্টর সাহেব কোর্টের অর্ডার অনুযায়ী
শুনুন, আপনাকে আপনি যদি যে অর্ডারটা দিয়ে আপনার পেয়ারটা ওরা রিজেক্ট করে দিল, এইটা যদি আপনি চ্যালেঞ্জ না করেন আইন অনুযায়ী, আপনি আর সেই বিষয়গুলো তুলতে পারেন না।
মাইলর এটা তো রিট পিটিশনের
ওই ওই অর্ডারটাকে আমরা বলি, ওই অর্ডারটাকে আপনি ফাইনাল হতে অ্যালাউ করে দিন,
এরকম তো মাইলর উদাহরণ
ঠিক আছে?
রয়েছে। না তো
আপনি তুলতে পারেন না, তা সত্ত্বেও আমরা আপনার বিষয়টা দেখলাম। দুটো বিষয় শুনুন, আপনার 200 স্কোয়ার ফিট আপনার গোডাউন বা অফিস অফিস নেই, আর ইন্টারভিউ কাকে কত দেবে এটা তাদের ব্যাপার। আমরা কখনো ওই ব্যাপারটা বিচার করতে পারি না যে আপনি ইন্টারভিউ একে 2 দিয়ে ভুল করেছেন, একে 3 দিয়ে ঠিক করেছেন।
মাইলর
এটা আমাদের বিষয়,
তারপরেও বলেন
ঠিক আছে?
কথা শোনা
আর কথা শোনা যাবে না, অনেকের
যেটা
মামলা আছে।
বলা হয়েছে মাইলর ওই গ্রামটা তোলা যাবে না মাইলর।
শুনেছি তো, আপনাকে শুনে তো
In
আমরা
this intercourt appeal, the petitioner
মাইলর রিট পিটিশনের ক্ষেত্রে মাইলর যেটা
Next, of the template consolidation.
Item,
Same order. Same break only take first election, last election, last 11 months.
9th March.
Second, in March. This last month.
Item number
3 and 7.
who is appearing for this? Today an adjournment has been prayed for on behalf of item 4. Item 4. শোনো চারের আগে 7 নম্বরটা দাও, তারপরে 4 2 3 and 7 এ অর্ডার হলো। বুঝছো না? হ্যাঁ, ঠিক আছে, এবার দেখো আইটেম
I appear on your decision, led by the London School of Economics. May we come to file my report?
But the APTVD opposition, we are filing the APTVD reply, they are taking. And there was also direction dated 16th of January that the copy of the notice will be served upon the non-appearing respondent to the proper respondent. This is the evidence difference.
হিয়ারিং ম্যাটার
No, not party. This is an application under it. The date is. Will kindly have a look at.
allow us to go to the order. 7th November, order is challenged.
The order has not been challenged. Kindly bear with
Order.
Order has not been challenged. Kindly bear for it.
Then what is the appeal for? You file appeal without challenging?
No. This is the vice honorable trial court, but no order has been challenged before the Lord.
We are not saying that.
Today's order is 17. Respectful groups.
Yes, Mr. Clerk.
Will kindly have a look at page 40.
No, no, what is the wrong with the order? Court has asked,
I'm showing.
the
Kindly have a
court
look.
asked for consideration of your 9th of April represent.
I did not sought for any consideration. There was no prayer in my retribution for seeking for consideration. Kindly have a look at page 40 of my stay application.
Page 40.
Fine.
Yes,
I made an application for a application, my lord, for a fair price shop. Pursuant to notice inviting application. The inspection has been conducted. Nothing has been informed to me subsequently thereafter. When I searched the browser, I find that, my lord, this has been uploaded in the, my lord, the site. Page 40. Kindly see. Vacancy ID, application ID, application name, date of the application, then rejected.
page 40.
Page 40 of this application.
Where is that rejected? Page 40.
Page 40, current status. Current status.
Page 40 is this page actually.
Page 40 is this one.
You are
41,
junior,
there is a-
sir.
Current,
Where is that sheet which you are showing?
Just a minute. Page below 62. I am showing page 62.
Now, page 40 is your application pursuant to which notification?
No, kindly have a look at page 60.
You applied on the basis of a notification.
Ma'am,
Which is that notification? Page 38.
page below. Yes, ma'am. 38.
So where is the vacancy? Vacancy is which vacancy?
12.
Serial 12.
12.
Serial 12. So pursuant to that, you submitted application page 40. Now page 60.
62.
Page 38 and 39 both.
Huh?
Page 38 and
39 notification.
Page 60.
62. 62.
Vacancy ID is under the application ID, applicant name, date of application 14th of August 2014. This is telling
Yes, yes.
current status reject. Very good.
So no reason has been given as to why my candidature has been rejected.
Right. Then in,
So I have to put this honorable.
without challenging that.
If I do not know the reason as to why my candidature has been rejected, so my lord, I will not be in a position to challenge. But I have challenged, my lord, the page 40, page 62.
What sort of a submission is this, Mr. Dutt? You are saying that as no reason given, I am not required to challenge this. That itself is the ground for challenging.
So my lord, challenging the propriety of the.
Show us the prayer. Show us the prayer question.
Yes, sir.
Mhm. How does you benefit? Why not challenging the record? Your prayer B is to rescind the decision of rejection
Yes.
without giving the date
Right.
and to reconsider the 14th August 24.
Yes, that has been.
So 14th August 24 has been directed to reconsider. Now,
Yes, ma'am.
we did 9th of representation, 9th of April 2020.
Yes.
Where is that representation? You filed the writ petition on 8th of September.
Page 61.
9th
There you
of minute, page
53. 51 of the same.
You said no inspection was conducted. Here you are saying inspection done. আমাদের বাড়ি টিফিন চলেছে আমার Page 60 অন্যদের বাড়ি টিফিন খুলেছে আমার
I can see.
No,
Eh?
all the three applicants, their application have been rejected. Let's see, all the three applicants who applied for that vacancy, all those applications have been rejected because they have not fulfilled the eligibility criteria.
So you will not tell him which eligibility criteria he did not fulfill.
Yes, that we have not, but in our affidavit.
Now what decision you have taken? Fresh notification?
Recommended for fresh note,
Recommended what?
for fresh note, not
No recommendation has yet been,
not yet been.
those two persons also preferred with petition.
No, they have not.
That has also been rejected in this fashion.
One. All three reports are rejection, that is anything in our affidavit.
So now court has rejected, considered the representation on 9th of April.
That
So
is the-
9th of April is considered and pass a reasoned order. What are the reasons for rejection?
this-
Milord, may I, sir? When the matter has
Now,
been taken,
so did you have you issued any memo inviting fresh notification? That has been done.
no, that has not yet been issued.
I don't know. It is in the offering, I understand it is in the offering.
Now, this order which has been passed, by this order you are under an obligation to consider.
That has
Uh,
So you consider and instead of rejected, you furnish the reason to this poor man so that he
Milord,
can.
Milord, may I, sir?
Yes,
May I, sir? Kindly have a look at page
34,
34 of my stay application.
30, yes, that is your petition ground.
No, Milord, the prayer.
34 is the prayer.
34 of the stay application.
State prayer.
repetition has been added in the stability.
No, he's showing us prayer of stay petition.
No,
Stay of read petition.
That
That
is
we are
a-
at page 34.
Yes,
Yeah.
yes.
B. Issue writ in the nature of mandamus commanding the respondent and each one of them and their subordinate and to such and such, particularly respondent number 3, to withdraw, annul, revoke, rescind and the decision rejection of the candidature of the writ petitioner in issuing the license of the fair price of being number such and such, and consider the application dated, which has already been filed. August 14, 2024 to the petitioner for reconsideration. So I have sought for challenging the propriety of the order of rejection. This writ petition shall be.
You said you have not challenged that order. Just now you said, I have not challenged that rejection order.
No, extremely sorry, Milord, that I have mistaken. I am mistaken, Milord, I am mistaken. So,
So
Milord,
where is your 14th of August representation, Mr.
no, 14th of August not representation. This is the application.
Because
Initial application by dint of which I have made the application.
that stage will come only after your grievance is considered, na? 14th of August is your application. for
Application,
vacancy.
application for the fair price.
That has been rejected. Now you are saying that, see, my prayer is, as you have rejected it without reason, you consider my application which I made pursuant to the
So the
notification.
subsequent development is, considering Milord this, your lordship was pleased to pass a direction to file a report. They have filed a report
আচ্ছা, দেখি কি report file.
in affidavit in opposition.
Affidavit in opposition. I take it for face.
That is say Milord, see, page 12,
Opposition page 12.
page 12.
Yes.
Kindly see left hand side above, eligibility criteria. Eligibility criteria, the applicant must fulfill the following eligibility criteria. Well, got it?
Page 12.
Page 12 of the affidavit in opposition filed by the
Clause.
clause 8.
Yes, eligibility.
The applicant must fulfill the following eligibility criteria. The applicant shall be an individual permanent residing such and such, registered partnership such and such, kindly have a look at 4, Roman 4. The requirement of the size of the godown and the shop for the running ration shop. The applicant should possess the suitable shop cum godown having following norms as per the notification issued by the department 1465 dated 14th of April 2023, read with such and such, such and such. Kindly take me, Lord.
You are applying for Panchayat area.
Yes. Kindly take me, Lord. Affidavit in reply, page 11. I have annexed that notification.
No, no, ultimately what did they say in the
You know,
opinion?
I'm showing. Prepare for a moment.
এখানে 17, কি 17 তো। Okay, we are come to page 17.
Come to page.
17.
You know, I'm coming.
Your specification regarding subcom meal.
17.
17, yes. 17, serial number 52. Right hand side, your specification. Your subcom 366.114 square foot.
This is erroneous, completely erroneous, because we don't kindly have a look at, I am showing the document.
3 square feet along with a covered area of 100 square feet.
They erroneously recorded the same. Kindly have a look at the document. I have uploaded this day application. Kindly see me in a read petition, page 55.
The total হচ্ছে 400 square.
Will kindly have a look at page 55 on my stay application.
Alright.
Kindly have a look at.
So now we will say that we are bearing unnecessarily, we will not bear. Now the entire notification has gone. All the persons are disqualified. You participate in the fresh selection. Finished. Who is stopping you from that? This chapter has gone. This chapter cannot be revived now. They have already taken a decision for not fresh notification. We will record that.
No document has been disclosed.
We will
They are
record.
saying something about that cannot be recorded. We don't kindly appreciate. There is no single averment in the affidavit in opposition that they have given a new notification. No single averment is there.
If there is new notification, you will apply. Is there any problem on the
thing? Only the difficulty is this: the falsity they have practiced. I intend to bring to your lordship notice. If your lordship consider that I don't have any case, I will go.
Yes.
Kindly have a look at page 55.
55
of my stay application.
Page 55.
Don't document. License value. I have uploaded.
Just page 50. Yes.
A certified surveyor measured the total godown, and this document has been uploaded in the survey at the time of making application. It appears from the document itself, the total godown is 689, office is 120. So if this someone records erroneous, so my candidature will be rejected. So
Where is that statement in page 59?
Page?
This argument which you are advancing.
Paragraph 16. Paragraph 16 of my
of your representation. Page 59.
Page
59, the representation which you made, which has been rejected to be 17 January 9, sorry,
that is not there. That is not there because at that point of time I am not aware. My candidature has been rejected, already been rejected. I am not aware. So therefore, I am not in a position to give these particulars. Kindly have a look at page 30 of my stay application. Page 30 of my stay application. Paragraph 16. Your petitioner states that the godown whose drawing has been uploaded is in 869 square feet, which is more than the requirement contained in the said notification of 400 square feet. So this is Milord covered area. Even after Milord getting this affidavit in opposition, once again I have measured to ascertain the carpet area also by a licensed valuer. He did so. Kindly have a look at my affidavit in reply appearing at page 10. Kindly bear with me.
Affidavit in reply.
Page 10. This is below certified by the surveyor by the license paper. Measurement has been conducted. Go down near Puriman 0.527 Borgofo. So this is carpet area also. So that to not to allay any confusion, even the carpet area has also been measured. This is 527 Borgo square feet. Officer Puriman 107 Borgofo. So that we not to allay any confusion, we have once again measured, and this is appearing.
This and page 55 of stay application is same.
Yes, these are the same mirror. These are the same. Only mirror. Kindly see.
Now this uploaded document is different from which you are saying.
No, only mirror. There was a toilet has been mentioned in a dot. The toilet has been marked, but mirror here the toilet has not been marked. The total area is the same sketch map, the same parcel has been measured. Even that person can come and affirm an affidavit, who is a licensed valuer, a licensed mirror the surveyor. So if there is a confusion of 10-20 that can be considered. But this is a huge amount. Why they are saying such an erroneous, they are practicing because the constitutional. You should not believe it. You should not believe it.
So why didn't you challenge this inquiry report has been not given to you? It has been brought
Right now has been produced. Inquiry was held in your presence. Every time they have recorded, there was a form. In the form also, they did not write anything. They asked me to put a signature, so I have taken this point. Kindly
That's what it says. That's what it says in court.
Yes, you tell us.
Kindly have a look at page 39. Page 39 of the affidavit in opposition.
Yes.
They have written 366.14. Page mirror 39 in the their affidavit in opposition.
Affidavit in opposition.
The same amount which has been mirrored, the same measurement has been recorded. And there is a signature of my client.
What is page 39?
Page 39 is a form which has been given to me, and subsequently mirrored all the handwritings is not mine. Everything has been written by them. So mirrored they handed over to only 2 portion has been written, the mirrored application number, and this one was printed. The other thing was not printed.
No, this was filled up by whom?
By the officers, by the
Your
inspection of the
signature is
officers.
there. Your signature is there.
Yes. Milord, that in my affidavit in reply, Milord, I have taken specific point that Milord, this form only printed 2 column and the rest of the amount was blank. He was asked me to put my signature because they have to prepare the inspection report. So they told me that the inspection, while the inspection report is prepared, I will put this amount.
So this was on the date of inspection.
The date on inspection.
So date of
And if that written minute as to why signature I know, I'm aware that mine is
that you
800.
go and ask your client that why did you put this?
So that has been taken,
That
in affidavit in reply.
This was not there in the representation. You ought to have said this. In the representation, you should have mentioned that. No. Inquiry was done in your presence. On that date, you are alleging a blank paper was
Not
taken.
blank, not blank.
Achha.
A form, where 2 entries has been made.
Date and I was asked to put my signature. So by putting that signature, you have not admitted anything. You show us that when did you raise this issue? After signature, when did you sign?
May I-
You have signed. When? What is the date of your sign? When was the inquiry held?
No date is mentioned about it. It is their document, now they are going.
Date of inquiry was 24th September 2024.
Yes.
Page 23.
Yes. A specific plea has been taken. Page 3, paragraph 2 of my affidavit in reply.
Mr. Dotto, we will ask him to make a fresh representation taking this point. Let your authority consider.
Yes.
And till such decision is taken, do not effect fresh notice.
Yes, logically, this is the previous page, page 30, you must have said. Page 30. But the last one is board. The logically, this is page 30.
Page
Logically,
38.
38 of the opposition.
Yes.
District level committee has not recommended. The vacancy may be re-notified.
Maybe.
Sorry.
Excuse me.
You are quite elder now. Please take your seat. Please take your seat.
This is on 28th of August 2025. We are in
28th of
August 2025.
where
The decision to re-notify
page
was it's 38 at the bottom.
which one you are showing?
Well,
38 at the bottom. This is which this is Purba Mendipur.
yes. Yes, yes. Well, multiple,
It is a recommendation.
no.
Recommendation made by
vacancy may be-
selection committee,
Yes.
district level fair price of selection committee. They recommended that we do not find any suitable candidate.
Yes.
The vacancy may be re-notified.
That's the decision
Yes.
taken on 28th of August 2025.
Yes, but we have been shown, and an issue has been raised, that despite the appellant, despite having a office space go down of 800 square feet, where your specific eligible criterion is that 400 square feet, you have not given him that license to him. This issue has been raised.
That's
There is a direction upon you to consider his representation. Although in that representation, this issue has not been raised, his contention is that this document has been just annexed with the affidavit in opposition. You have never,
secretary to the author of this document. Supposing he bears his signature. He participated in the inquiry.
mayor
His
putting a signature will not increase the area, size of area, will not decrease the size of area. What is the size of area is a question of fact.
Fact. The district court may not deal with that.
Not that. If and go down of 800 square feet, 800 and odd square feet is shown to be a go down of 300 square feet. Such question of fact may be ascertained. You appoint a special officer or any expert person. If it is done, then it is not legal,
No, my lord, what you can see is,
and it would be injustice. What your
now,
stand?
my lord, what you kindly see is that this, maybe, my lord, there was a finding of the competent authority, that's why there was no recommendation, and that's why there was a, all things, it's not that the distribution has been meted out to the.
Your measurement was taken by your official.
Yes.
He is not sole licensed surveyor or any expert to take measurement. Whereas the person having expertise to take measurement of a page has certified the same. In case of conflict,
The benefit of that document, my lord, that is one of the licensed for the authority, as I understand. But, my lord, that was done, my lord, by the petitioner himself, not, the authority has no knowledge about the measurement taking process, how the
Okay,
measurement was taken.
you said that you uploaded that measurement conducted at the time of initial application. How you have uploaded?
You know, we have to upload it. There is a requirement.
Where is that? Sure.
Notification.
Page 12 is the notification. Where is that provision that you have to upload?
Both. Page 39.
Page 39 of the reply.
Of this day application.
39. The 39 is that your signature. I'm not saying that.
Stay application.
Stay application. Bengal.
পরিষ্কার ভাবে প্রস্তুত গোডাউনের নকশা আপলোড
আপলোড করতে হবে।
প্রস্তুতকারকের নাম যেন পরিষ্কার ভাবে এই 39
No, that has been.
অ্যাপ্লিকেশন যেটা আপলোড
Then see 59.
So then Mr.
55 will also connect with page 55, I am told.
55 of
Of the petition P3. District Pro Manager for Nanda Kumar Swayam, the measurement is in feet. The handscape map is not scale. Then village concrete road, plot number 993, plot number 994. What is 120 square feet? Go down. Now, please,
that is what we are wondering. If his case is, if it is according to him, his go down is above 800. But on inspection, we have found it to be 366.
because I understand that there is.
And you justify that you are relying upon a declaration made by. You justify that it was 366. He himself has admitted according to.
Yes.
So when if he has uploaded a document showing the measurement to be 800, why will a person write down say that it is 300?
That is one of the inspecting authority, they verify.
Exactly, you ascertain that. If you find that this document was not taken into consideration, you take consequential steps.
One of the, but one of the may, yes, that direction that may be given, but one of.
No, we will only say
Public distribution system may not be hampered, it will stay.
within 1 week you will do it. He will file within 1 week. We can, if you want, we can fix the date and time. You hear him, finish it off next day. Because Mr. Doctor, you have not challenged the Rich Court order. Rich Court order said, all right, there are some problems. He has made a representation, you consider. Now, when evidence were called for, he has showed us this. So we will say enclose everything and make a representation. Afresh, we will record his contention and we will record your contention also.
when we got one of the test of one of the notification is stored on that way.
We will say that if it is, if it goes against you, if it goes against him, you will be free to recommend. We stopping it. The time out. Recommendation. That school will they can effect.
But the instruction is one of the decision of rejection.
Or Mr. Dotto, we can say this.
1% এখানে 20.33 দেখিয়েছে, এই 20.33 into 18.1 আর ও বলছে 20.3 ঠিক আছে, 20.3 বা 33, বাট এটা 31 ফুট 4 ইঞ্চি।
No, এটা তো this is different from the one which has.
No, that portion has been shown same, 24.3 inches. But here in place of 31.4 inches, it has been shown as 18.01.
So one is blanket, one is covering.
Authenticity of the uploaded document showing the godown space is not was considered by the officer rejected. Because
They have uploaded,
one of the document is not known, who has done it. It was uploaded, no doubt, but the authenticity or veracity of the document has to be established by the author of the document only.
If the structure is not more than 50, 1,000 authentication certificates file will not be relevant. On seeing you are conducting an inquiry which you have done and said that it is 366. That is your observation, page 7. Now, authentic question is you go and see if it is more than, if it pertains to the same what has been registered, reject his claim. We are not stopping him.
Not the, I don't know what is going to happen, but all.
No, we
all
can do
applications have been
this.
rejected.
But
All applications have been rejected for different reasons. One of the petitioners has come before us, one of the applicants is before us. Now, since there is already a decision to re-notify,
when was the decision taken?
August 2025.
it is recommendation, it is just recommendation
Recommendation.
by the selection committee. Selection committee has no right to re-notify. Re-notified would be by the department,
Yes.
by the department.
It was prior to the court, sir. 28 August, prior to this reach. We can do this month, we can do this. We can fix a date of hearing and the submission. And you conduct an inspection. If so required, you conduct an inspection and take a final decision within 2 weeks. And we will say that it will not, this declaration of vacancy should not be made for a period of 2 weeks there.
Okay, now,
Entire thing has to be opened. If the decision to be notified, then in effect, is stands nullified. Because we lost his order, because that will open the selection process again. And this is the registration here. Am I clear to your lordship? Possibly I am not clear. Now, if there is a decision taken at the administrative level, to re-notify, there is a recommendation, of course, the department has not as yet taken a notification. That we do not know exactly as on of now. But if that is done, then there are two others. They may come. I don't know what is going to be. They may come for their to the defense. That I do not know.
No, we are not on that. Mr. Dotto, only one thing is troubling us. Good, bad, indifferent, the document has been uploaded, for which there is a provision under the notification. There has to be a consideration of this aspect. You said rejected. That you ought not to have said at that juncture. Then you
That's
should
why
have
there was
said,
a direction to consider the representation.
being a statutory authority, you cannot simply say rejected.
No, this
So-
is have to be,
so
it's to be
Mr.
informed decision.
At the time of such rejection, you could have recorded that the uploaded document measurement does not tally with the physical inspection. Finished. You did not do that. Yes, inquiry report is there.
Okay, you notified the vacancy in 2024 August. And you conducted inquiry in August 2025. And till what happened, the ration, those who are the beneficiary, they are attached with the next dealer.
Yes.
So they are not being deprived of.
The rational system,
Uh,
distribution system is in order.
so they are attached with
No, we
another.
are not injuncting, we are not reopening the entire thing. We are not saying that we are reopening, we are saying you will consider this aspect. You take your reasoned decision.
Yes, September 24, 2024 is the date of inquiry. Not 25.
The problem was created by you, sir. You said rejected. This is not done, na? A rejected, suppose if it is a genuine
Right
case.
for the reason.
If it is a genuine case, in that case, the person goes, na? Representative has been preferred. Challenging and order.
Keep the points open for us so that the office can.
Certainly. Challenging and order.
Item number 5.
5 তো হয়ে গেল।
No, I.
ওকে ওকে 2, 3, 7 yes.
But, there is a attack in the proceeding pending before your lordship at the instance of the district controller.
আজকে তোমার ইয়েটা রাজীব
He did not appear before the authority, he did not appear before the appeal. But the state authority is supporting him. Because already information that we gathered by way of public, by way of through RTI, that the land belonging to him as shown to be having the title in respect in favor of the private respondent, that land does not belong. That allegation was specifically made. We wanted the cancellation of the fair price plus of license in his favor before the court below. We did not say anything to the learned trial judge. That consider my learned trial judge without going into anything, had directly consideration of it. Include order that was passed on 24th of November 2025. Kindly look for once and page 166 for once. I would request you not to. That is what I am. Conservation does not survive. The order is due, has been acted upon. And he
Acted upon?
participated. Yes.
he participated.
Yes.
So where is the order?
I have gathered a supplementary affidavit before I take your lordship to that matter. I am just making out your lordship.
It is hard made. When the order has been complied with, what appeal?
Order has been complied with in spite of the fact that lordship has taken cognizance of the matter and directed him to take instructions. Immediately
He
after that,
participated. Participated.
I was called on 14th of January to the office.
Where is this, sir?
Page 15. That is the supplementary affidavit we have. They have filed. They have disclosed that. An application is there, Malad can do.
Okay, take liberty and file a fresh petition.
That is exactly, Malad, I am worried that this question will come from, but this is how it has been given birth. This should not have been done by the district controller when the court is in the season of the matter. 27th of this January, he cannot do this because 16th of January, court has not given the order. That will take instructions in this matter.
Both of you will lose a forum. If we
I was surprised how my client
go
will go
into
there.
that
He
extent
referred to the notice.
to
But also will kindly
examine
look
the
at
legality or
who communicated
validity
the
of
order.
this order.
The order was not communicated to him. He was unaware about the said order. It was never informed to him.
This is best, provide this application, this will be
Comment.
Application means appeal, not the application. I have not filed the application.
On 16th of January 2026, we heard the matter.
Yes.
So on that date, it was your responsibility to tell us that I have attended a hearing on 10th January. Kindly see page 50.
Yes,
Last
16th of
line.
January, Malad, yes.
So you should have told us, sir. Then we could not have called for any, we would have passed appropriate direction. Was it not your duty to tell us that this has been the
Definitely,
development?
I should have. I was thinking as surprise.
On
That this
14th
particular,
14th notice was given, 8th of January notice given. Page 13 was the notice.
24th November, the order was passed by the learned trial judge ex parte against all respondents. No one appeared. Include order, no one appeared for. I was directed to communicate the order and within
So
certain time you
your
had complied.
this was that appeared on 14 January.
We passed order on
Page 13, the notice. 8th January notice,
challenge.
16th,
No.
14th January.
And petitioner was heard on 10 January. As per notice dated 23rd December. Where is the 23rd December notice 25?
But that is not 23rd December notice is not.
23rd December 28.
Only 8th of January notice was given, page 30.
Of the earlier compliance of High Court. Attend.
The gentleman, my client
Order was passed on, order issued was
24th,
April 27th November,
24th.
when no one appeared, not stay. Who, but once we don't communicate, my lord, even in contempt matters, they are seeing the years are passing over, but they are not complying. So active the district controller, without being communicated, even he has immediately jumped up on the issue and protected his own wrong committed by him. Fraud has been committed. If the village man has gone there, but that does not matter. It's not to matter. Accept the illegality committed on the face of it. On the face of it. Only one issue I will be raising. You have committed total matter of corruption. Absolute corruption. And you as a even on the day when the matter was taken up, not an advocate, government leader also did not disclose that there is a hearing conducted on 14th. তোমাকে জানো 16th even he did not inform.
You get information fast. You get instruction.
And after this, he need to communicate. How could he communicate the order on 27?
No comment.
The order to the communicate. 27th January he communicated when the matter is before the High Court division.
what is your challenge in the
Kindly one thing, only one document I shall be showing you. Not nothing further. Kindly come to page 103 for once. I wanted to know, this gentleman, you have allotted the land, fair price was taken, whether this gentleman had a title over the property or not. Yes, he has given an answer, page 103. In RTI.
yes, what he said?
But in correspondence with the letter dated so and so, alert plot number 368516 have been emerged from original RS plot number 368 and during revision and settlement. Furthermore, Osima BB recorded 0.24 acres and 0.9 acres of land in favor of herself in plot number so and so as per the mother of the allotee. Hotel number from Kalu Sheikh and Damun Sheikh under mutation case number so and so to registered deed number 8466 of 1983 by DSR Raigot.
So where does Shahiduddin come?
Shahiduddin, Asima Bibi has donated the land in favor of Shahid.
How did you come to that?
I have given that document. But kindly, first of all, Asima Bibi's title has been said but by deed number 8466. But kindly mark and come to page 120.
0.24 acres and 0.09 acres.
By deed number 8466. Last sentence.
Yes.
Kindly come to deed number 8466, 120 page. 120 page. That is my question, madam. 8466 deed number is between the third other person, not Aspa Bibi. He is not a party to the same thing.
Who was not a party?
Aspa Bibi. Aspa Bibi has allegedly purchased this property through deed number 8466. That is the case.
So this is 8466 where yes, deed number 846.
So kindly madam, come to deed number 8463 at page 120.
Recorded in favor from with a mutation case. There was a mutation case through the registered.
Yes, come to the mutation case, page 105.
105.
Yes.
Yes. What you want to know of this?
Their deed number 1192 has been mentioned also. Examine the document produced. Who has produced this document?
Are were you a party to this mutation proceeding?
I was not a party in the same.
You have purchased from Osima.
I am not party.
Yes.
I am independent land.
Shahiduddin purchased.
Shahiduddin said that I am the grandson of Osima. Therefore, deed of gift was given, grandson or son of Oshima.
How can
And-
we consider these issues?
That Oshima had no title, there is a fraud committed. Oshima has no title in the property.
So should we consider?
That document is there annexed.
Civil court.
No question of civil soul. How could you act upon the same? I have given the document.
Why did you appear then, 10th of January? Why didn't you tell us that we have filed the appeal? In the meantime, they are taking a decision. I was asked to appear.
That.
So, Mr. Bharat, how can,
Now, Madam, I can suffering that. I have answered to that. License. I have not ignored that.
If
License.
If
License has been
you
questioned.
invite us,
He has not. Constantly not happening. You are protecting him.
Mr. Bhattacharya, if you invite us to examine the origin order, then both of you will lose a quorum. You go to the single bench, let the single bench consider, then if it is not considered in your favor, then come.
But again, they will be pending the appeal. How could they issue the order?
All right,
How could
we
they
have
issue the
not, we
order?
have not injuncted them.
yes.
Take, what is the lordship's order? I read it for once, lordship's
we-
own order, division. 16th order. Hearing to not 16th order. 16th order, they do. Yes.
এইটা
আর ওখানে 10 তারিখ আর 14 তারিখে দিয়ে
এখানে কি দেন আপনি?
10 তারিখ আর 14 তারিখ যাই হোক হিয়ারিং দিয়ে আফটার অ্যাফোর্ডিং
Mr. Dotto Lane,
Order.
government appearing for the same shall avail all necessary instruction.
order under appeal has been acted upon. Order
what is
under
there,
appeal
right?
has been acted upon. There is no order now. There is no order.
the present appeal has been preferred, challenging an order.
10th of January hearing given.
Yes, next.
Item number 6.
Last time was a clarification short call. Short call.
Mr. Ghosh, comment, we have one matter. Service is complete.
Yes, please, all for. All
All
are
are
done.
happy.
All are done.
That is complete. Something is For what?
We found that the
Yes.
Item number 6. Application can be disposed of along with that. This application can be disposed of along with that. Because they have not approached the first, the honorable single bench. They just come up before your lordship directly.
They are similarly situated.
No, by submission, will be decided by your lordship. Whether
Even here.
kindly look at the include order.
Which page?
In my application.
You have filed an application on leave to appeal.
No, no,
You are Sunil Dotto.
no, I'm not sure. My application is Shakina Begum, the appellate. Perhaps you're also looking at the addition of party.
Which order you are assailing?
But page 332 of my act,
27 November.
27 number.
You are the private respondent.
I was the private respondent number 6. Right, challenge the component of
Where
the
that give us. Disposal of appeal means which appeal?
Itara is pending before your lordship. But I have challenged the component of the order, paragraph 8, 9, and lordship the 10. Because this writ petition is not at all, my petition is not at all connected with this Itara. The fact is purely different. But single judge, but adding or observing that this
Which for
matter,
the writ petition I responded.
The extension of it, order is under.
no, but I've challenged, my application has been kept in abeyance. My application has been kept in abeyance.
Extension of.
Considering the fact can shall be taken up for hearing after disposal of that. My application has been not kept in abeyance. My only fear was my application for bracketing the interim order.
That is can 3.
That is cancelled. That is should be hard by the honorable Speaker. My only prayer today. And the fact which has
So
been
it will
recorded
be
by
hard. It has not been disposed of.
no, it has been kept in abeyance because the honorable single bench, kindly see paragraph 8, on hearing the learned counsel for the parties and on perusal of the material on record, it appears that the petitioner hearing has challenged the selection process. This is completely a wrong record. The writ petitioner filed a writ petition on the ground that his application for compassionate appointment as the MR dealership has been rejected. Number, he filed a writ petition. During the before filing of the writ petition, the particular vacancy was bifurcated into 3 vacancies. Number, government has published a notification. I appeared in the advertisement and I have selected. Number, license has been given to me. Suppressing that fact, a writ petition has been filed, challenging the impugned order whereby the writ petitioner's application for compassionate ground was rejected. Number, honorable single bench, please to pass an interim order of status.
For that reason, in spite of receiving the getting the dealership, I could not run. I filed an application for addition of party. My application was allowed. Thereafter, I filed an application for bracketing of the entry bond. Since the substance due to the substance.
What was the hearing?
The entry order was, well, may I show it to your lordship the exact entry order is. But kindly come to page 225. No, 291. Can you come to page 290? 291 is the order started, and 296 is the portion of the order. 294, my lord, I will say. Considering such circumstances, let there be an ad interim order of injunction restricting the respondent to proceed with 2 memos dated so and so for filling up the FPS vacancy, particular of which are mentioned in prayer H. Before the passing of this in
Page 200 and
I start from page 291 and relevant para is page 294. Paragraph 12.
So when was your license issued?
My license issued on 25th of July 2025, page 319.
25th of July.
July
25.
25. And our interim order was passed on 30th July 2020.
This is a page.
But my license, page 311, 309.
So then who is operating?
No, the person whose it has been tagged, the entire license has been tagged to some other person. He is right.
Due to this interim order.
Due to this interim.
It has already been tagged with others.
Yes.
Your license has.
But what happened, the father of the petitioner was the MP tag. He died in 2013. Not after his death, similar petition filed from this court by his legal counsel. Praying for the license under capacity. All the petitions were initially heard and the interim order of status quo was passed by the honorable. Now, during pendency of the order of status quo, the government published a notification thereby bifurcating the said license into 3 categories, the 3 different dealers.
No, when was it tagged, Mr. Ghosh?
13.
Then what is the urgency?
Not I have been
Status quo has been directed to be maintained. Now
there-
you want to
thereafter the
detag and those and give it to you.
yes,
This
because
is your
I-
ultimate
yes,
plan.
yes, ma'am. My application should be heard. My application for backing of the interim order.
May I suggest only the subject to lordship consideration. The entire application can be heard by the learned commission with the direction for filing because the vacancy under can in my because in terms of the order of status during the existence of the order of status 3 vacancies have been published. Out of that, the learned secretary just again that one vacancy has rightly been notified, other 2 vacancies are not right. And in one such vacancy, my learned friends have applied. If I succeed in the repetition, all those 2 vacancies will move. And I will remove the international.
Sir, Tara, why should await the decision in appeal?
That is my
Why this application consideration should await the decision in appeal?
No.
That is
That extension of indemnity, your lordship may modify. Your lordship may remember in 2013 control order is under challenge for your lordship hearing the matter. Whether 2013 has granted or not. These vacancies, these have also been issued 2013 control order. The court's observation was that if the 2013 control order ultimately declared by the judicial bench redundant, those vacancies will also. That was the reason for the extension of interim order following 2013. But I don't say whether if your lordship modify the interim order, the interim order will contribute to the disposal of the repetition and the learned single judge may dispose of the repetition within a certain time.
What will not dispose of on the plea that appeal is pending?
No, you should modify the order.
my
Modify the order. I stick to my learned.
also let
You are
the
saying that
The interim order will contribute till disposal of the repetition as has been passed by Justice Parthaswamy Sheikh at the initial stage. In the meantime, direction for filing exchanging immediately, your lordship may request the landed signature to dispose of the matter at the
The interim order was not till disposal.
because my
Correction.
application for
So then,
consideration.
your application will be treated as an opposition.
File.
No, but the application is only for the vacating of the interim order. My contention to the honorable signature was the petition was filed suppressing the fact that before after rejection of their prayer, the vacancy has been given to me. That has been suppressed and the order of interim order has been obtained by the honorable. That was my specific case with the honorable single. And when my application for addition of party was allowed, honorable single bench pleased to observe that also. Yes, since you have been not heard, you are given liberty to file an application for vacating the interim. But my today also is that I'm joining. Let the interim order be modified.
Initially, let us arrange the fact. Initially, the hair pipe hog was allotted to one person.
One person.
Then that person died.
Yes.
Upon demise of that person, you and other legal heirs
No,
apply.
I'm not a
Just,
I am 100% legal respondent number 7.
give the just short fact.
Yes,
My father was a rabbi shopkeeper.
yes.
I applied for the vacancy.
I am the one of the legal heirs.
Okay, okay. Yes.
Or other legal heirs also applied. Two repetition was filed. In one repetition, cancellation of the prayer for composition appointment was challenged by one of the legal heirs. In my petition, I challenged the pendency of my application for master. In that petition, Justice Devashish Kalpurte as Lordship Jonas passed an order of status. During pendency of that status order existence, 3 vacancies have been notified. Considering all the ration cards which have been detached from my father and tagged with the other. I came before this honorable court during existence of the interim order, these vacancies cannot be notified. That petition was ultimately heard, and Justice Samanta came to a conclusion that out of 3 vacancies, 1 vacancy is not from the card of your deceased. That is, before your father died, some cards have been detached from him on a punishment. So you have no right to cut those cards are concerned. I have accepted that petition. The court directed to consider my application for composition appointment.
In respect of which vacancy?
But may I
Vacancies. 2 vacancies. Out of 3, 2 vacancies. Now my PR has been rejected on my flimsy doubt that the legal heirs have not given their without considering the aspects that Justice Samanta held in terms of a division bench judgment. A person who is not eligible, from him no NOC is required to be submitted. In a previous proceeding, it has been held, all other legal heirs are not entitled to get the license since they are not eligible. So in that case, division bench held in other proceedings that no NOC is required from the other legal heirs. Even then, my application has been rejected. Rejection of my application for compulsion account in my previous present petition. At that particular point of time, in the meantime, I have came to learn subsequently he got the license. What passed an order of status?
What the license in respect of 2.
Out of 1, out of 2, 1. Out of 2, 1. Now my landed is coming from the another one. So today, my lord, entire issue is required to be heard by the single bench. Which is followed from your lordship, this application may be considered as an opposition, and your lordship may modify the order to the extent that the interim order will continue till disposal of the restriction, and a request may be made to the landed signature to dispose of the matter as early as possible.
Then his interim order prayer for vacating
But prayer for vacating interim order means for the final hearing of the restriction. Yes.
your submission, but when an application is filed, the court should return a finding that I cannot vacate it.
But possibly, my lord,
So
but
we can modify the order to this effect that this.
in that case, I shall have to file my opposition to the application for vacating.
Yes, we will allow it.
This is the
my prayer principle of the interim order should be restricted, should be some certain period, not till disposal of it. Otherwise, the restriction will never be.
your lordship request the landed signature.
হ্যাঁ, যেটা 2013 control order
Because under the definition specific point is that the vacancies
No,
those
Mr. Sarai, this rider considering the facts, the application for vacating order will be taken up for disposal after disposal of the appeal.
I am not accepting. Your lordship modified it. The learned feel that proceeded on the basis that if the division bench ultimately held that 2013 controller became redundant by virtue of the coming into force of National Security Act and 2015 Central Controller, then all the vacancies will be. That was the reason because Justice Paul was carrying out so many matters so far this point is concerned and passing interim order following your lordship division bench order, sitting with Justice.
Subject to correction while
So,
landing.
I am your lordship. So,
আমরাই তো দিতে হবে।
No, no, regarding this issue,
Regarding
regarding this issue,
interim order is more than
regarding these three vacancies, these vacancies, subject vacancy, three writ petition are pending.
No, two writ, one writ petition is pending.
one. This is the only.
Only one. My land is senior appendix.
If he has to
Earlier-
Earlier three writ.
and another one, your lordship absolutely correct. Justice Borbuk is statement.
No, no, that is to the.
So, everything, nothing, today only.
Only one.
Other writ petition are disposed.
So if the writ petition is decided on merit, everything will
Yes.
regarding this.
This maximum application possibly cannot be decided by the learned familiar because entire issue will be out of court if the vacancy application hard and my right accrues in regard to the declaration of my specific submission before the court that during existence of the order of status quo declare the vacancy which is not permissible. If I succeed in that matter, this vacancy will be the vacancy
For correction, but my land.
license, everything will be.
Subject to correction of my land senior can say the honorable single bench while dispose of the writ petition of my land senior in 2023, but not recorded any finding to that effect. Not declared that the other two vacancies have been declared illegal. The order
Mr. Ghosh, we understand. Mr. Sarai is not standing in the way.
yes, yes, I accept my
Modify, but the thing is, will this modification ultimately help you? Or we will say you dispose of the writ?
Number subject to
Suppose
correction.
today you file a vacating application, we modify the order. Then Mr. Sarai will come and say, I believe it's an opposition.
Number that's true.
So the issue lingers.
Number kindly kindly pass on request to the order single judge to dispose of the writ petition at the earliest
Yes.
possible.
In that
And
circumstances,
second level, interim order should not be till disposal. If that be so, it will be very difficult to alert the dispose of the writ.
You can be joined there. Your lordship,
Kindly
Mr.
don't
Ghosh-
the interim order till disposal.
Mr. Ghosh, why interim order is passed? Don't take it as all, why interim order? To preserve the subject matter of the litigation
Yes.
until disposal.
I bow.
So that during pendency of this, anything is not happened, we will change the subject matter.
I bow down. I bow down.
You
If-
tell us whether you are agreeable to treat that as an opposition. That we will specify the time for reply and we will request the learned court below to finally decide.
No, I require to be certain.
Eh,
Require to be certain, not entirely. And I have no objection whether we'll get the lordship, the license or not. Because two vacancies are right now is there. Not the state in the affidavit.
Tell us what do you want? Do you want your vacating application to
Yes.
be independently heard? That will create more difficulty.
Then kindly fix the petition for hearing.
Yes.
Treat my vacating application, my position.
That is what we are asking.
Yes.
Yes. And only the interim order may be on a limited period, not the.
No, still that.
But kindly consider these actions. But
Then
I
we will
We will limit.
because out of two vacancies, one vacancy has given to
We are
me.
not going into the merits.
No, but I'm not.
We will record Mr. Sarai's contention that he would make a joint prayer along with you for finally disposal of the matter.
My that will be also be harder.
তাহলে আমার পার্থক্য তো হলো।
yes, possibly, sir.
Why you are getting yourself added here? You have an independent writ.
I have been lordship kindly transfer it out. Page 11 and 12 of my
No,
application.
so it becomes cumbrous. We can say this that your writ petition which is pending can be heard along with this writ petition.
Yes, then
Then also sir.
so we are adding it, otherwise we shall not be able to pass any order.
But if you have to add to that, the
Add to
petition is
the
going to be amended part of
You have to make an application.
for the other single bench also. Because they cannot jump upon this honorable court and pass it.
Have your petition number, na? So we will incorporate this, we heard you as an intervener. We will dispose of your application, saying that as you have filed a independent writ, that will be heard with the consent of both the parties along with that.
My-
The present appeal was preferred challenging the
ঠিক আছে।
এটার সামনে
Requested
Item number 8,
and an advocate for the applicant to report not to take it.
2 weeks, নাম্বার 8 টাকে ফিক্স করে করবে মানে টিউসডে উইক
And next week, I think.
নেক্সট নাম্বার 9
নাম্বার 9
item number 9 is in 9 sir 2 weeks next 10 item number 10 item number
9.
we have kept it next week.
No, no, my lord, I was also looking at my lord, I have approached this court in order the petitioner to be allowed for a second chance, my lord. It has already been done, my lord can dispose of the.
9
Yes, sir.
the 9 টা দাও একটু 9 অল্টারনেট করো ওটা তো নট স্পিক করেছে আগেরটা লিখে দিয়েছো তো
হ্যাঁ,
এবার 9 এর ফাইলটা দাও
The petitioner was called on 5th February, my lord, he attended, my lord, therefore our main grievance has been.
read
the learned advocate appeal for the appellant submits, comma, upon instruction, comma, that the appellant's grievance has been redressed in the pendency of the present. In view thereof, the appellant does not want to proceed with the appeal any further. Accordingly, the appeal and the connected application are dismissed as withdrawn.
My lord, can my lord add just one more line that the reasoned order passed by the concerned authority be communicated to only this.
When was the order passed?
5th February, the meeting was held on 5th February of this month. But the reason order till date has not yet been communicated. It might be communicated within few days.
And they have done so that which code direction is already there. Yes. Next item number 10 for is for the appellant state. Then we keep it up. Item number 10.
The difficulty is there is a question that
Hmm.
is solved, and after that, we are citing that is a reason we mentioned that.
Oh, I see.
But if this is a point is involved in this appeal, which has already been decided by the coordinate commission and upon by all.
Who is appearing for the state?
Mr. Officer said, communicated by the coordinate of
Why they are not here? देखिए की order is coming for the first time. Then there is a section 5. How many days delay?
Yep.
91 days.
There are other defects also. Appeal number 2, the memorandum of appeal, appeal number 2.
Is not a party.
Joint secretary was not party to the issue. That could be there. Yes. Appeal number 2, secretary, joint secretary.
Joint secretary was not a party in the petition.
Just to what has happened is that a license was issued to a particular person in terms of a vacancy notice. Subsequently, they cancelled the license, stating that the conversion certificate that was produced was not genuine. But that was not issued at the time of giving the appointment. And subsequently, it was discovered that there was some mistake, and he sought to rectify those mistakes from the land department. But they said that you have acted fraud, so your license is cancelled.
Well, the decision means the coordinate decision means that already held that is not a mandatory document for giving license for dealership. It's an optional document. If from the other document it is satisfied that there was a go down, the property is not a rural land or a agricultural land, then that is not a mandatory document. And that judgment has been upheld by the Supreme Court. So today this point is probably
This Archana Jana.
Archana Jana and there was another judgment which went up to we covered the judgment, but it went up to the Supreme Court and the Supreme Court. Probably this point is no more open for question.
আজকে সংশোধন you have not
Where is the contempt fees?
There is there in the list of justice.
To proceed with the contempt.
In the list, I have already taken up on five.
You are there for the appellant.
But let me understand.
The petitioner is contempt.
But they have, this is a defective appeal, not an appeal in the eye of law.
My lord.
I am told that it is coming for the first time.
Yes, it is contempt.
They come next Tuesday. If they do not come, we dismiss the appeal. Not. Yes, next.
When it will appear next.
Next Tuesday. You inform Amritolal Chatter
Yes, yes, thank you.
that court will dismiss it if you do that. Yes.
Okay, Lord.
Next Tuesday.
Question number 11. No, 11 I am for that.
Oh, next Tuesday is a holiday. That Tuesday, no, sorry. 24th, yes. Yes, sir.
I am for that.
No, no, 3 সময় ডাকো এবার। 3 হয়তো There were 3 p.m. fixed, madam. Yes, Mr. Samim, where you are? You are ready?
Item
Shall
number
we conclude today?
21 fixed matter.
Sometime I will try to assist this court in my way. Because of that, this matter, after review, one application, and that application was cancelled because of that is wrongly recorded. Why? Because of that, that's for my assertion of that matter. Because of that matter, the file was not with the court. So, the court tries to get the copy from the petitioner as well as the respondent. From that, wrong recording of the application number, because in his record, it is recorded in CAN 3. That's why CAN 3 is disposed of on here. That's my assertion. It is evident from that order. That is 11th December 2020.
You come this side.
it is an application for recalling.
After
The application which is still alive
alive application is now CAN 2. CAN 3 is disposed earlier. Why this is? I
So it is recalling of the order passed on a review application.
review application. And why it is recalling this you want,
What is recalling? Recalling means
I don't go to the
recalling means again review.
again review, but that's not permissible. Only the inherent power can exercise.
Now inherent power cannot be exercised in
Yes.
violation
Until and unless grave
in
injustice.
violation of any provision.
Yes.
Now order 47 rule 9. Have you worked the CPC?
Yes.
Very good. Order
Yes,
47
yes,
rule.
yes.
Order 47 rule 9 you read.
I got
Huh?
this flagged in my bar of certain application. No
Yeah.
application to review an order made on an application or a degree or order passed or made on shall be entered. There is a specific bar, my lord. Others,
They speak bar.
yes.
So which the legislature has prohibited, that cannot be done in exercise of your inherent power.
Yes, no doubt.
So how
I-
can you entertain?
My lord, I want to, my lord. Yeah.
Which was
Well,
state, which was state.
Along with Mr. Basu, the state.
No, there are certain factual issues. Do you want to apprise us on those facts? Because it is relating to appointment of the person as an organizing teacher.
The Basu will but I will try to. Mr. Rajoshi Basu.
Oh,
Earlier occasion,
Yes, he was there. Where is he?
Another content matter to what
it is as per my assessment and my junior's endeavor, my lord, I got this is my lord, ninth round of litigation. It starts from the year 1983 and thereafter 1988, thereafter 1993, thereafter 2002, thereafter 2004, thereafter 2014, 15 and 2023. But what happened, my lord, I just keep the nutshell. What
No,
happened,
what is your opinion? How can we exercise this power?
my lord, with greatest of respect, my lord, in which ground, my lord, that is, my lord, kindly see his prayer. I have, my lord, initially I have a doubt, my lord, whether court can exercise on this. My lord, now I am clear that court can. Why, my lord? At least part. Why? My lord, I will show, my lord, from this application itself. Kindly see on which ground he wants to call. My lord, court, what, my lord, take a step forward. Why? I say so, my lord. Kindly see the can do application para 20. Which ground he wants that kindly see para 20. Kindly see the application.
is the application.
Please take us to the facts. What happened?
Yes, my lord. But what happened, my lord, he is an organizing teacher. In the year,
Fight the dog.
He paid for recalling of which order? Order passed on review application? Huh? All order?
what to, my lord. Otherwise, my lord, it is not possible. But I
Which
believe, my
order
lord,
we
that
shall
when
recall now?
although his prayer is the 14 January 2015 order, my lord. But I believe he should perjury.
Application
Why?
করা যাবে না মানে ফাইল কপি নেই এই তো আমার কাছে কপি আছে
একটাই দিয়েছে।
এটা
Some of
Yes, please.
Oh, yes, yes.
Please.
There are 29.
No, reach, first, take us to
Yes.
the order which he wants to record it. That is page 57.
Very good. And the term of page 41. Number 41.
Yes,
Inflation.
this is 14 January 2015.
Yes.
You want to place this order?
But I believe that
Appeal could not.
yes, you want. But kindly start
No, no,
starting from
give us 2 minutes.
I want to start from page number 37.
Acha, we are
But because of
now,
kindly read the original read from it. It will be helpful. Page number
just 2 minutes, 2 minutes. When was the appeal dismissed?
Appeal dismissed.
on appeal dismissal 14 January 2015. That is page number 41.
14 January 2015, the review file was dismissed in
No, ma'am.
27.
Appeal dismissed. Mandamus appeal dismissed 14 January 2015. Thereafter, I
Filed a review appeal.
review application. That is page number 44.
That was dismissed on 27 November 2018. Now, after that, he has filed this application in the year 2023.
23. In the meanwhile, another application which is also required, that is CAN 3, which is annexed to this application, page number 57. CAN 3. Page number 53.
53.
57. 87.
57 is the order of 70.
Yes, madam. That is CAN 3. That is CAN 3.
Yes, that is this. Where do we find this CAN 3?
CAN 3, my lord, is not with the record, my lord. My lord will got
So,
this order, my lord.
He
Glimpses of
filed
this
another application, CAN 2. This is the
CAN, which
after
is
dismissal he has come.
because of that, why this is as numbered as CAN 2 and 3, why this confusion is cropped up, my lord, because which is narrated in 11 December 2025 order. Kindly see 11 December 2025 order. My lord's order. It is my lord's order. 11 December 2025. My lord's order. What I gathered from this.
Now, whether CAN 3 at all filed?
Yes, CAN 3 and CAN 2 both fine. Although CAN 3 ought to be CAN 2 and CAN 2 ought to be the CAN 3. Due to file was not available with this court record, that's why wrongly in court record it is become CAN 3. Kindly see 11 December 2025 order. Kindly see first 3 lines. Today the matter has been placed in the list for hearing of the application being CAN 3 of 2020. However, the said application is not on file. In view thereof, Mr. Devabrata Bera, appearing as applicant in person, has handed over a copy of such application to Mr. Basu, learned advocate representing the state responsible. Upon verification of the same, Mr. Basu has expressed his satisfaction regarding the authenticity and genuinity of such application. In view thereof, the copy of the said application is taken on. So, my lord, for that reason, my lord, because he handed over
So can two is an application for recalling an order of fasting review.
review. As well as, my lord, he wants the recalling of the appeal, mandamus appeal also. Because of that, my lord, can you see that what is the prayer? Prayer is that, my lord, 14th January 2020, 2015. My lord, an error apparent on the test record, my lord, what is this prayer? Although, my lord, that is, my lord, I believe, my lord, this court, my lord, ought to
14
January 2015. My lord, can you
page 8.
page 32 of the CAN 2 application. That is his prayer. In view of 3 paragraphs, which is narrated in this CAN application, specifically para 29, gathered, my lord. Because of that, my lord,
No, no,
wrong.
let us understand. The appeal was dismissed on 14 January 2015.
Thereafter,
He
review
filed a review application. What was the number of that review application?
that is annexed with my
51 of 2015.
my lord, 51 of 2015, page number 44.
Page number 40.
44.
Achha. This review application was dismissed?
On 27 November 2018.
Yes.
Thereafter, he
Which
filed,
application?
actually, he subsequently filed 2 applications.
Not required. That this has been treated as the recalling application. Now, please your.
Yes. What happened was in this case was that he appointed in the year 1979 as an organizing officer. Thereafter, my lord, DLIT inspection. Thereafter, my lord, several proceedings was initiated. Why? Initially, my lord, there is an objection that his graduate degree is a fake. In the year 1988, he successfully established that his graduate degree is not a head degree. Honorable Justice Mohitos Majumdar in the year 1991 passed an order. In pursuance of that, he able to establish that his degree is not a fake degree. Thereafter, my lord, court, my lord, give a direction upon the DI that you passed an independent order. DI somehow, my lord, he not passed the independent order.
No, he was an organizer teacher, not given appointment.
Not given up. Not
Initially,
given approval. I could say because of that, in the year 1979, 1978, another teacher, that is Haradhan Mondal,
Maradon got appointment.
appointed.
There was one vacancy.
But there, at that point of time, with the best of the manner, there is no such question of academic arose. Because of that, this is the 4th class.
Very good. Why his prayer was rejected at that time?
At that time, due to, well, first time, due to fake graduate degree.
Was there any order to that effect?
Yes,
By the DI?
no money. Well, in the year, that is, yes, at that point of time,
79.
79.
Huh.
And ultimately, established his case in the year
Is
1991.
that 79 order?
Well, kindly see, I did not get it, well, all the order, because some of the pages I got it, that is, because it's a very old record, which they handed, which he handed over, because all the pages is not with me. So I did not
But
get
how
hold
did-
of that, but I got hold of this, all this order from a DSC order, reason order, which is challenged in the writ petition itself. But kindly see
Take us
that
to the
DSC, that would be the more beneficial for the court as well as DSC order.
challenging which the writ
The
petition
writ petition
and appeal
was,
was
yes.
dismissed.
DSC order. Writ petition. Any copy? But I think the court still got one or two. They should hold that this order is absolutely fine. But yeah, if I don't not feel it, I don't.
সুরজিৎ কোথায়? খোঁজো না একটু অর্ডারটা কি বলছে?
আমি এটা
কত ডেট
পরে কাজগুলো করবো।
What is the date of that order? That's very good. You start placing. it.
11 November 2003.
DSC order is 11th November,
2003.
11 November 2003. Very good. This was preferred challenge in a writ petition.
In a writ
Now,
petition,
writ petition when order was passed.
the writ petition order was 26 July, the 30, which is annexed with this application, that is
26 July
2030.
after 10 years. That's show us that order.
That are page number 37.
Page 37. Yes.
But if my notes are not getting one, and
We have got it, page 37. Oh, yes.
the petitioner challenged. The petitioner challenged an order dated October 28, 2003. That is this.
Said 11th November,
No,
28 October 2003. Very good.
somehow it's wrongly recorded, the order itself. Because of that, the original order shows, my lord, this is 11th November. As per.
Okay,
That
order
way,
passed by the
communicating
director.
memo.
But communication memo, not.
Anyway, you are sure this is the order, na?
My lord, I can't record that is the order. Maybe the memo dated with. Passed by the Director of School Education pursuant to a previous order of this court of October 7, 2002. The order dated October 7, 2002 directed the Director of School Education to consider the case of approval of the petition as an organizing teacher in the Arun Chandra Junior High School, Atiberia, in accordance with law. But after giving all concerned and opportunity of hearing, the order of this court of October 7, 2002 specifically provided that in deciding the matter, the director will remain uninfluenced with the observation made by the district inspector concerned on 5th December 2001, and he will decide the matter independently. The director has passed the impugned order after noticing the observation in the order dated October 7, 2000. The director has indicated the reason for declining the relief sought by the petitioner by referring to the qualification of the petitioner, the staff at the concerned school, and the requirement of the school. The order appeared to be well written and indicates the application of the director's mind to the matter issue. There is no grievance that the director did not grant the petitioner. The primary objection of the petitioner is that director may have influenced by the order of October 6, 2001 passed by the district inspector. The reason furnished by the director in the order impugned do not refer to the previous order and the district inspector of October or 6, 2001. The director appears to have arrived at an independent finding without relying on order of the district inspector. Since the decision-making process does not appear to be arbitrary and cogent ground have been indicated as to why the director found that the petitioner was not entitled to any relief, WPA number such as that is dismissed, and the challenge to the relevant order is rejected. There will be no order as to what that is done. So says that the director was well reasoned order. Now, what was the director's order? Because of that, director order was well reasoned, but with the I could say actually not correct. Because why say so? In the year 2003, when the staff pattern evolved, at that point of time, pure science, because he is a teacher of pure science, the staff pattern was not there. But when this director filed an affidavit, that affidavit is clearly narrated that in the year 2009, there is no such matching vacancy. But at that point of time, in the year 2008, Haradhan Mondal retired from the service. In the year 2009, when director filed the affidavit, at that point of time, that post was vacant. That was never narrated because he gave a wrong affidavit at that point. Because in the year 2009, vacancy was there. He says no such matching vacancy. That's the question. Because in the affidavit itself,
Whose evidence?
the director affidavit, or director filed an affidavit in the writ petition. In this writ petition, in the year 2000, there was a direction for the affidavit.
Unless we have those papers, how can we?
Malala, he got hold of it, that paper mallet somehow mallet with
All right.
great
No,
effort of
you first.
mallet kindly see the evidence because that was
See, before page 41, the appeal court, what did say? After Sanjeev Banerjee's order, what did the appeal court say?
appeal court appeal court finding is very important.
His, no,
I read
his challenge was that the observations of the DI in the earlier order,
Court direction was that without influence by that DI order because you passed
where
an
is that
independent
DI
order.
order? Where is that DI order?
That DI order is not.
Now you are showing, now you are saying this issue which you are raising, this was not there in here. This was not raised. So Mr. Shamim, how can, in the interest of justice, how can we say now that you argue a point which was at your hand at the time of disposal of?
Interest of respect, because of that, why I say so, kindly see how could I get hold of that information? That's most important. How can I hold kindly can't pay of this information? That is most important. In any proceedings, knowledge is very important. Page number 61.
Yes.
Kindly see, this is an RTI reply. What is when I got this RTI reply in the year 2018? What is
Yes.
see the details of Haradan Mandal. Second column. Haradan Mandal approval memo number started search. Date of joining, second column. Sorry, third column, and the last column, date of retirement. 2008. Now, kindly see what evidence used in the writ proceedings, and what evidence in opposition. Evidence in opposition. Opposition. Evidence in opposition. Kindly see, or kindly ignore the because kindly there are several. But ignore it, I will try. Or kindly turn page number 3, D. Paragraph 3D. On which that this evidence came up.
This evidence was filed in
On 13 November 2009 by one Shubhendu Ghosh, son of late Satyal Sach, aged about 45 years, life years, residing at Satyal Sach, who hereby solemnly affirms says that I am the Assistant Director of School Education of West Bengal and am conversant with the fact and circumstance of the case. I have been authorized by the respondent number 2 to affirm the instant evidence on his behalf and competent to do so. So it is filed on behalf of the DSC. Kindly turn page number 3, para 3, subpara D. That is most important. And now, thereafter, I will place the appeals court. Page number 40. May I read one? That upon upgradation of the school in question, it become entitled to 3 more teaching posts in addition to existing 3 teaching posts, against which 1 teacher in language group, Gorango Sasmo, 1 teacher in social science group, Nitai Charan Bera, and 1 teacher in bioscience, Triveni Chokroksi. It is not out of place to mention here that the qualification of the petitioner is BSc pure, and there is already an approved teacher in pure science, namely Sri Haradan Mandal, having qualification BSc pure in the 2 class junior high school. Moreover, after the upgradation, the school required a teacher of bioscience and has the approval of appointment of the lead petitioner as organized teacher being graduation in bioscience does not arise at all. In the year 2009, 70. At that point of time, Haradhan Mondal was LDC as per the RTI reply,
2008.
2008 retired. But on that point of time, a wrong evidence. At that point of time, the question arose, at that point of what was his age? His age was 50. If correct fact arose at that point of time,
What was the correct?
that fact because of that Haradhan Mondal was not in service, that means pure science post was vacant. He, being an organizing teacher from 1989,
How? Which he was,
pure science.
he retired on
And
31st
first
January 2008. 31st January 2008, Haradhan retired. So at that time, read petition was disposed of on 6th of July 2013. That is 5 years thereafter.
Yes.
Yes, then what you are saying in
But
this?
when I came up with that, when it came up in my knowledge in the year 2008, that's why I'm going to kindly turn page number 61. Kindly turn over
What came to your notice?
retirement, date of retirement, kindly see of Haradhan Mondal, page number 61. Side by side, kindly page number 61 of Canton.
Side by side what?
With this document, Canton, page number 61.
So very good, he retired.
Kindly see when I came to know that's the most important thing. That is in the year 2018.
This business. 2018 is the application. Read petition is over by that time. So how can we help you to that effect? His case is that my certificate, ingenuity of my certificate, the list was concluded ultimately on the basis of Justice Mohitos Mohita's judgment. So I in fact was entitled to be placed at the time of Haradhan, but I was not given. That was 1978. Read petition thereafter disposed of in the year 2013. After 2013, RTI obtained after disposal of appeal also. 2018, appeal was disposed of on by order 27 November 2018. This was in his hand when the appeal was being heard, because he obtained this on 12th of April 2018. So he could have showed this to the appeal court.
Initially, suppose one of the proceedings going on, the person give the evidence, article 12 authority give an evidence that ought to be a true evidence. I accept it. But kindly visualize. When the proceedings was going on, first time, my lord, they arose the question about my genuinity of my certificate. The whole endeavor of the Article 12 authority is that not give appointment. That's my whole purpose of this argument. First time they arose the question about my genuinity of my certificate. Thereafter, when I satisfied through court, my lord, thereafter they arose another question that is
Satisfied through court, where is that order?
That order, my lord.
What was the prayer in that?
1991 order. That order is not as the whole because that's the old record.
What was the ultimate direction?
Maybe.
Hmm.
In 4th June 1991, the last paragraph. According to the University Authority, constitute the grounds for taking an appropriate action in those circumstances. The order of the university quoted above cannot be sustained on the ground of breach of body or other party. Well, the petitioner shall be treated as successful candidate, and he shall not be otherwise deprived of the benefit which would have been made available to him had he not been trusted with the order.
So this was on 4th of June 91.
1991. That is
Huh.
from
Then
Justice
we-
Mohitus Monika passed.
So in the writ petition which was filed in the year 2004, that must have been told.
Yes, yes, no doubt about it. At that point of time, when 2004 writ petition filed against that GST order, that GST order says that there is no such staff pattern, matching staff pattern. You are a successful, that you are a pure science. Now your certificate is genuine. Now the question is that there is no such matching staff pattern. That's why you are not eligible for getting appointed. That is the ultimate order of that DSC. That order, he challenged that order in the year 2004.
Please give us those, please give us copies. Please give us.
I believe,
Yes.
I can may place it on the old DSC order, which is challenged.
হ্যাঁ, তাই তো বলেছে একটাই ভ্যাকেন্সি একটা ও যেটা বলছে ক্লাসের কোন সাব প্যাটার্ন সেরকম ছিল।
This wrong affidavit came up because that might
What is
change
the
the scenario.
wrong? What is the wrong in the evidence?
Kindly see, there is a grave wrong. Kindly see affidavit in opposition, para 3D, this portion.
In 2082, consider in 1982, or you said that I was engaged in 1979. In 1979, the school was a two-class junior high school.
Yes, yes.
So now at that time, what two-class junior high school would get how many teachers in science subject?
At that point of time, two teachers.
Two
One
class.
is, yes, one is Aladun Mondal, appointed in the year 1978.
অ্যাপয়েন্টমেন্ট অ্যাপ্রুভড হয়নি ওদের। ক্লাসটা ছিল 1982 করে আপডেট। ওদের অ্যাপয়েন্টমেন্টটা তার মধ্যে হাজির হয়েছে
The school was recognized up to class 2
Yes.
junior high school,
Hmm.
class 2. Then in 1982, it was upgraded up to class 4 junior high school. It is correct. So 1978 would get only one teacher, one science teacher. So Dharadon was appointed or engaged in 1978. So in 1979, the petitioner cannot have got any vacant post to be engaged or appointed
At that point,
because the school is then only one teacher.
interest of respect, at that point of time, there was no such staff pattern. Kindly say. Because of that, what happened in the case of organizing teacher, the teachers, they organized it. The teachers who organize the school according to the departmental requisition.
If that is the case, that ground also it could have been agitated.
Yes, no doubt. I am not bargaining with
So
you.
how can we?
That ought to are good in that case. But that is, I know where I got that argument. Nowhere I got. I admit it. I admit. But the fact is that the only way to entry in this case is possible the way of purchase. That's my humble understanding. Maybe I am wrong. But only
Why Parjuri? What?
actually because of that in the year 2009. An affidavit came up that 2000, although the Haradan Mandal retired in the year 2008, a wrong affidavit came up that he is in service.
Which was that?
Well, kindly see the affidavit in opposition which I handed over, page 3, subpara 3D. Well, side by side, just keep
Yes, yes. 61.
61. I just read it slowly. That upon upgradation of the school in question, it became entitled to 3 more teaching posts in addition to
Upgradation is in 82.
82 place. From 2 class to 4 class. Against which one teacher in language group, Gorango Shasun, one teacher in social science group, Taichoron Mira, and one teacher in bioscience, Tribeni Chakraborty Oera. It is not out of place to mention that the qualification of the petitioner is BSc pure, and there is already an approved teacher in pure science, namely C. Haradon, having qualification BSc science in 2 class junior high school. Now, kindly turn when this affidavit came up.
Yes, yes, you are right.
2009.
2009.
So,
how does this observation help you?
If at that
Now
point of
he has
time,
retired in 2000.
a person being an organizing teacher gave service since 1979 up to 2009. That means almost 30 years. At that point of time, in that year 2009, his age was 53. I calculated. If
No, what is the wrong with this sentence? It is said that your statement is this is affirmed in 2009, but he retired in 2008. So this statement ought not to have been made. Now, if this, assuming your submission is correct, by this statement, what right has accrued? No, what right has accrued in your favor by this statement?
Because of that, what is the objection in PSC's order? There is no such matching vacancy as per the staff pattern.
We have no. Yes.
What is kindly see the yes. What was the DSC's order? Why DSC says he is not entitled to get appointment because of there is no such matching vacancy.
What relief can we give today? We will deduct compensation.
But otherwise, no such relief until and unless that is the only relief. At least, 2 things. One is that wrong affidavit, partially positive.
No, what part, sir?
This is
That is a wrong statement. That is a wrong statement accepted. How does the wrong statement help you?
Because of that.
It is not a case. It is not a case that in 1978 Haradon was not appointed.
Yes,
it is not a case that Haradon was junior team. It is also not a case that Haradon in any manner prevented him from getting the job because his qualification was in doubt. Where is the part, jury, sir?
But it is a case. It is a case. I was appointed.
Maybe
I was appointed. Initially, why my
So
approval?
then all litigations which are 40 years old, a person can come with an RTI reply after 40 years and say that at that time the appeal court did not consider it proper. This is absurd, Mr.
With greatest of respect, I
Absurd, you know.
am trying to. I am trying
Even
to.
if
I am
the
assist that one because of that one. I am trying to assist one. Yeah, but why? Because of that is important. Initially, why approval was not given? Because it says his certificate is not genuine. It's fixed. So ground of rejection of my approval was that fixed certificate. At that point of time. At that point of time, staff pattern never arose by any of the article paper. In the year 1980, when DLIT inspection was there, at that point of time, they also not arose this question. DI also not arose this question. What was the rejection of my approval? Reason of the rejection was that my lord fake certificate. At that
Not
point,
on the ground of staff pattern.
not on the
Now,
ground of
where is
staff
the DAC observation you are trying to
Yes,
show us?
but the whole, I believe, this is, I think 3 pages, 4 pages, order, I just assist the court,
To bring this order, we will go. Huh?
I handed over, The whole fact is marinating.
You know, there were 2 teachers.
But mother, only it pinched me, because of that person.
No, we are not annoyed with you. We are trying to prosecute that query.
Yes, yes, but I want more closing, because of kindly see this DSC order.
Your argument is this, as we have understood. In 2-class junior high school, there was no issue of staff pattern.
Stop at that point.
When 1978 appointment was given, Paradon got appointment, my appointment, be that for whatever reason, for it was only on the ground of my qualification.
Yes.
It is not that I was denied since the staff pattern did not provide another. So when my right you have taken away on the basis of a certificate wrongly issued by the authority. Court after so many years comes and says that your declaration is right, you are a graduate, and said that you are entitled to all consequential benefits. So in that case, he ought to have preferred a contempt against that. He ought to have, he had a good case.
He preferred a contempt.
Then what happened?
But in contempt of 500 cost was imposed upon the DI. And thereafter, for that reason, this DSC order came up. Why this DSC order came up? Thereafter, in contempt proceedings, after imposing 500 rupees cost to the DI, the further repetition came up. In that order, there was a narration that you will not influence by the DI order, because DI just copy paste it, that same thing, that his qualification is not as the requisite qualification. That's the reason, DSC order came.
Then Mr. Shamin, you bring these 2 documents, give us a copy of this. My brother is.
Yes. I thought that copy with
No,
my lord, that's why,
we are giving you back these 2 office.
Yes, I just came up with.
If you please, if you can make a compilation of the
Yes,
documents.
that is more helpful, but for that reason, well, I made a list of date as well as the list case history details, well, junior PRD. I will try, well. The only remedy is left out in this case is that, well, I thought of that. Only,
Stage we are going in the circle.
yes, but
Division bench dismiss or dispose of that.
yes, review.
Later patents appeal.
Let us-
Thereafter, a review application was filed. That was dismissed. Another application was filed seeking review. That was also dismissed. Now, this application has been filed.
I believe.
In the cost title, it is consequential orders or relief. In the pair portion, exercise the power of review.
The only power left out to this court is the parent power.
No.
And that too, my lord, case of grave injustice. But I could say, my lord, this is although not figured as a grave injustice, but it's a figure that is injustice.
No,
My lord,
shall we pass any order in can 3?
my lord, in this,
So shall we recall all the order passed in appeal, review and review? Then we have to pass order.
yes, because of that, my lord, an important fact, which is, my lord, I believe, my lord, in this case, my lord, which is throughout negative, my lord. In the writ proceedings also, my lord, that's why I placed the writ order, my lord. That is an important fact. When that matter was adjudicated, at that point of in the year 2009 itself, he was 53 years old. When he was engaged, staff pattern was not in question. In the year 2009 also, that post became vacant. So that question, that important.
Okay, that is
had
the
been
fact.
passed.
That
Yes,
is the fact.
Not in law.
In which application or appeal we shall pass this one? In math.
Malad have to pass this order. Otherwise, this all
Okay.
are
So
also-
math has been dismissed.
Yes.
Math has been dismissed. So if we want to pass any order, we have to recall the dismissal order.
The only ground is that one legal, Latin maxim actress get cured in every habit. But court can rectify its own wrong, but I could not say it's a wrong. I can't say it's a wrong. But that's the, I could say, one important factual aspect throughout the proceedings, somehow ignored. That's my humble submission. Now, the nicety of laws, I believe that ought to be there. That ought to be there. But the fact is that a person, a citizen of India, is deprived. Is deprived. First, an article
There
to
must be a
authority,
finality of litigation.
from
We
this
have to
proceeding.
stop at one point. There must be finality of litigation.
Yes.
One litigation cannot be allowed to be continued for an indefinite period.
But when
And hence there is a period of limitation also.
Of this argument is part by constructive res judicata.
yes,
What to have been taken earlier, what he is arguing at present.
yes, no doubt about it. It is ignored, but one important development is that I could say, that's my only point. That is that when it is came to my knowledge, came to my knowledge in the year 2000. This factual aspect came to in my knowledge. That is page number 61. That is the only when it is in my knowledge, but I am not.
Did you take that ground in appeal? What you are arguing? That was also not. That ground was also not.
In the year 2018, because the appeal disposed of in the year 2018. But I got this information because there is no scope to take the ground in the year 2000 because the appeal filed in the year 2015. And appeal filed in the year 2015, that is, and review also filed in the year 2015. Sorry, Malad, with greatest of respect.
If we direct payment of certain amount of compensation upon the state, state will may go to the
Yes, but there is a very good case. Why? But kindly see the date of dismissal of the review. That is judgment date 27th November 2018. So kindly turn page number 44. Kindly turn page number 61. That is 12 April 2018.
Yes,
Well, they can
I
take
didn't
it.
find that this point was taken in subject to correction. The point which you are arguing so vociferously, this is not there.
That's the I believe it is a fit case for because a new fact came up. Although a prudent man giving in all due diligence is not there, so it is a fit case for review, no doubt about it. But because of that, in the year 12 April 2018, it is came to his knowledge. So if a new fact came up, because of that one, that is the new fact.
It came to his knowledge in 2008,
18.
2018. That is only prior to the review application was hard.
Review application is hard, but this is I don't know which date. Yes. Copy. Review copy is also not in. The review copy.
When the trials court passed the order in 2015,
At that point of time, that information is not with me. That was not in my knowledge. So if subsequent with after giving a due diligence, if after giving a due diligence, if a person not get that information, but subsequently came his knowledge, it is a ground for it, no doubt about it.
Mr. Shamin, can you say 2008 person retired? He got so much of relief after 7 years when he came and filed the
Until and unless one of the greatest of respect.
that unless it is intimated to you, you will not come to learn.
Until
There has to be diligence on your part also. Your colleague engaged in 78, any person will know that he will be having a retiring date. This is nothing, a representation which has been made. We do not know on legal advice or somewhat. This representation has been made on 28th of March 2018. 2005, the Right to Information Act came
Yes.
into being. So 13 years I don't do anything. How can now we, moreover, kindly come to the order of the division bench?
Yes.
That is at page 41.
41.
What you are arguing is here. It is true that the applicant's case was delayed because of his disputed graduate qualification.
That's why I want to.
Now, let us, even if we ignore this
Yes.
today and go back to 1983, we are not in a, court is trying to visualize the situation as existing in 82.
yes.
At 82, the person was appointed.
But in the meanwhile, Maran, give enough 30 years. Given a person given Maran service at that point of time.
Mr. Shamin, when one organizing on school, organizing school is recognized, and the staff, organizing teaching staff are their service is approved. Then the existing on that date, who was teaching, who were teaching,
Yes.
and their name is reflected in the DLIT report, then their service will be approved. It is not that let the teacher retire, thereafter another teacher, organizing teacher will be approved in his place.
With greatest of respect, Maran, at that point of time, what is the reason of the non-approval? And take graduation degree. But that is not a thing. Ultimate go in the year 1991, it is proved that my certificate is genuine. Thereafter also, the DI passed the same order. That's why in the contempt proceedings, 500 rupees cost was imposed.
Where is the DI order?
DI order. But it is reflected in DSC order. DI
That's
order.
also not even the copy to us. All right, we have heard you. You do one thing.
Yes.
Any judgment to your side?
Maran, Next state, my lord, I try to give us more. Because of that, my lord is well aware that here Amtole, there are 238, my lord, and the last completion was I handed over that.
No,
In this case, my lord, what to be?
Mr. Swami, we are fixing a date again, but ask your junior to
No,
give
yes.
us the document which
In a compilation,
Ah.
in a compilation, also, along with the list of date and along with the list of cases
Ah,
which I
that-
my lord, gathered till date, my lord.
So tell us when can you come and finish it up?
After. But I also, because he's a aged person, I'm trying to gather the fact by interviewing. I would like to ballot more document if I got board on it,
Yeah, Adal on it,